Thank you. All right, good evening, everyone. Once again, we're just going to call the business meeting to order. So with that, I want to go ahead. We have a quorum still. Thank you. Then we will proceed. At this time, I believe everyone has received a copy of the minutes from September 10th. Has everyone received and reviewed a copy of the minutes? If so, at this time, I'll have a motion to approve the minutes. In a second.
Second.
Thank you. It's been moved and properly seconded to approve the minutes from September 10th. All those in favor?
Aye.
Okay, there's only one. Thank you. All those not in favor? All those opposed? Thank you. The minutes have been approved. We will now hear from the guidelines subcommittee. Dr. Sule, are you going to introduce the minutes?
Yeah, Judge Shaw, did you want to say anything or do you want me to just jump right in?
I thought we might want to go back to the discussion from the public meeting about expungements and thank Mr. Fincy because it was he who really brought this topic to our attention. And it's my understanding that he is going to take the lead in trying to, he's been voluntold. But no, he brought it to our attention. I think it's a very important issue, particularly for defense attorneys. And he and Dr. Sule really have engaged in conversations since our meeting to try to bring it forward to more defense attorney associations and groups around the state. So on behalf of the subcommittee, I want to thank you for bringing it to our attention, first of all, and for, as I said, volunteering. With that, we're going to discuss the guidelines, the proposal with respect to the prior adult criminal record. And I mean, I'm happy to let staff give their report, but I did want to note that we have had some discussions at that time with respect to the impact that drug charges have had on criminal records in the past, and the fact that we have had significant changes. The offender score, as you will hear, hasn't really been changed significantly in like 40 years. So obviously the issues with respect to marijuana and all of those convictions, we at least need to look at whether we make a change, as Mr. Harvey said, is a different matter, but at least we'll be exploring it. With that.
Thank you,
Thank
Judge
you.
Shaw. So yeah, so we're going to have, just to summarize, the guidelines subcommittee met on November 18th via video conference, and all our subcommittee members were able to participate. So we had two issues that we discussed that we'll be presenting you today, and Ms. Bowles is going to start our discussion regarding the proposal to study the prior adult criminal record. So I'm going to turn it over to Sarah.
Good evening. Okay, I think this is working. Thank you. So the corresponding memo we'll be talking about is the proposal to study the prior adult criminal record score component of the offender score. And as you all probably remember, this proposal was one of the recommendations included in the Commission's 2023 report, an analysis of racial differences in sentencing events. As you know, the prior adult criminal record score is one component of the guidelines offender score, and it classifies the adult prior record into one of four categories, either none, minor, moderate, or major, based on the number and severity of one's prior adjudications. Placement is based on a matrix, and numerous different combinations of offenses can place someone in the minor, moderate, and major categories. In the race report, we looked at the number and severity of offenses that compose defendants' prior record scores. For those analyses, we used prior record data that was previously obtained for the Commission's 2018 juvenile delinquency study. And this data included guidelines individuals sentenced from 2008 through 2012. One reason for including these analyses in the report was the concern expressed by some practitioners that defendants were scoring major prior records based on the accumulation of multiple minor offenses. So for instance, multiple violations for driving on a suspended license. Our analyses didn't suggest that this was the case. Very few defendants scored a major prior record based on the accumulation of multiple minor offenses. We did, however, find that Black guidelines individuals sentenced from 2008 through 2012, on average, scored higher on the prior adult record score than white, Hispanic, or other race individuals. Black guidelines individuals on average were also more likely than individuals of any other race to have any prior adult criminal record, to have a greater number of prior adult adjudications, and to have a record of more serious prior adult adjudications. These differences in prior records in part explain the generally higher incarceration rates and longer sentences observed among Black guideline sentenced individuals relative to white individuals. While these findings were a good starting point, our ability to draw conclusions based on them was limited due to the age of the data and some issues with missing data. Therefore, the Commission included in the report the recommendation that the Commission conduct a new study specifically assessing whether the offender score may be amended to reduce previously existing racial and ethnic differences. The details of this proposed study are included in the memo. This new study would replicate some of the analyses we included in the race report, including looking at the number and severity of defendants' prior adult adjudications. As Judge Shaw noted, we would also be looking at drug offenses now. And the staff also suggested that the new study examine the application of the criminal record decay factor. The decay factor allows for the prior record score to be reduced by 1 level if the defendant has lived in the community for at least 10 years prior to the instant offense without any criminal justice system involvement resulting from an adjudication or a plea of no contest. To complete this study, we will need prior record or rap sheet data from the Department of Public Safety and Correctional Services. And we've started discussing the logistics of this request with Angelina Guarino, who we have here tonight, Secretary Scruggs' representative. We look forward to working with her and the department on this project. So our hope is to obtain the data in 2025. We've included an estimated timeline at the end of the memo. At this point, the timeline is tentative and it will depend on exactly when we receive the data. But once we receive the data, we estimate it will take about 10 months or 8 months to prepare and analyze it. At that point, the staff would then present its findings to the subcommittee and then to the full commission. I would note at this time that these analyses are exploratory. So the commission may review the results and take some action. It may decide to take no action. The guidelines subcommittee unanimously agreed to recommend the proposal while acknowledging that the study should proceed without any preconceived decisions about future policy decisions. That concludes my summary of the proposal. I'm happy to answer any questions, but otherwise I will turn it over to the commission. Thank you.
Thank you, Sarah.
So with that, if there are no questions, the subcommittee is recommending that we vote favorably on this research item.
Thank you. It's been moved, well, there's a motion to adopt a proposal to study prior adult criminal record scores. Thank you. It's been moved and properly seconded that we adopt the proposal to study prior adult criminal records. All those in favor?
Aye.
Thank you. All those opposed? The motion carries.
Okay, great. The second item that the subcommittee discussed is something that came up during a judicial feedback meeting. So those are the meetings that I conduct with judges from around the state. Recently in September, I had a meeting with the judges in the First Judicial Circuit. One of the judges at the end of the meeting asked whether the Sentencing Commission would consider automatically assigning victim injury points in the sentencing guidelines offense score in cases involving child sex abuse. This judge and his colleague noted that a strong argument could be made that the Sentencing Commission should consider revising this rule similar to how the commission revised the rule regarding child pornography. So as a reminder, or for those who are new to the commission, in October of 2021, this commission adopted revisions to instruct that permanent victim injury points shall be awarded in cases involving evidence of child pornography. Specifically, the revisions instruct that offenses involving photographic or video evidence of child pornography shall be scored as permanent victim injury. The revisions were adopted to recognize that photographic and video evidence of child pornography often exist in perpetuity, and the victims of these crimes suffer lasting psychological consequences and are re-victimized every time an image is viewed, possessed, or distributed. The judge that I met with noted that Senate Bill 17 from the 2022 legislative session requires judges to now receive 20 hours of training before presiding over child custody cases involving child abuse or domestic violence. And he further noted that during that training, judges learned that research shows that even nonverbal infants suffer serious and permanent injury from child abuse. There is an abundance of well-documented research showing the long-term effects and impacts of sex abuse. The judge was kind enough to share some of that research with the staff, and we will review the research to prepare a corresponding research memorandum on this topic if this committee should choose to assign this topic to the subcommittee for further review. The judge and his colleagues informed me that they believe it would be appropriate for the commission to consider amending the sentencing guidelines to instruct that permanent victim injury points shall be assigned for child sex abuse cases in Part B of the guidelines offense score. Given the judge's direct request, I brought this issue to the attention of the subcommittee. The subcommittee agreed to recommend to the full commission at this meeting that the topic should be assigned to the subcommittee for further review. If the commission agrees with this recommendation, the staff will then prepare a memorandum to guide the subcommittee review most likely at its next meeting, which is yet to be scheduled, but likely we're going to target a meeting for April 2025 since the full commission next meets. We're going to discuss the commission schedule, 2025 schedule, but likely in May. Finally, the subcommittee thought it would be helpful to invite the judges who brought this issue to my attention to speak at today's hearing. Unfortunately, neither of the judges were available, but we could consider, inviting them again when and if this commission puts this item on the agenda for a vote. So that concludes my report. And again, I think Judge Shaw would probably say it, but this was unanimous, believe that the subcommittee agreed that this issue should be assigned to the subcommittee for further review.
So I would just say that I think that anytime a judge is asking us to examine something, that we should take that very seriously. Judges are the ones who are obviously involved in determining the guidelines and sentencing individuals. And particularly in these cases, there's a lot of sensitivity involved. And we want to be sure that we are doing things that are appropriate in terms of assisting victims and witnesses. So I would like for us, or the subcommittee would like for us to approve this also. So motion to approve the examination of the points with respect to victim injury in child abuse cases. And I would ask that we move forward with the recommendation today, and that maybe at our next meeting, if the judges are available, they would come and speak, so that everyone on the commission can understand why they believe it's so important and why we do as well.
Yes.
So the law that was referenced was my bill. I'm the guy who passed that bill. The issue of sex abuse in children is a really serious issue and very difficult to get at, which is why the bill requires 20 hours of training for judges who are going to sit on those cases. I don't think it's well enough understood about what damage such actions do to kids, not just temporarily, but forever. So I totally support this, and I'll second it.
Thank you.
Let me just add my vote of support. When it came up at the subcommittee, I went back and talked to the prosecutor in my office, who was one of the top prosecutors in the state in child abuse cases. Her name is Becky Cordero. And I was really surprised to learn that points are not always awarded in these kinds of cases. Sometimes they are, but it's really a matter of discretion with the state's attorney and a matter of examining the victim and whether his psychological or physical are actually there. So I think this is a very important area. She was very much in support of the commission taking a look at this. So I vote in favor.
Okay, okay, thank you. Mr. Finchie?
Yes, I support looking at this issue because the judge has brought it to our attention. But I want the commission to know that in cases where I have handled sex abuse of minor convictions, it's almost always assigned as a point for the offense level. So I have a little bit of different experience than Becky has had in Calvert County, perhaps. And I would also note that sentences for, and I think while we look at this, we should also be looking at sentences for sex abuse of a minor. The sentencings are I think, very high. You would find, I don't think you'd find low-end sentences in most situations. I think you'd find middle to high-end sentences in many cases. So I think as part of it, we should also look at the actual statistics for that particular crime.
So I want to be clear about what the motion is then. Because are we asking to amend the motion from just inquiring to examine assigning points in the sentencing guidelines often score for victim injury cases involving child sexual abuse and also sentencing?
Well, that's not really what we voted on, but I believe that the subcommittee is in accord with his recommendation. So I would say vote.
Okay. Since I've restated the motion and it's been restated, is there a second? Thank you.
Second.
Thank you. It's been moved and properly seconded that the commission refer or inquire to examine assigning points in the sentencing guidelines often score for victim injuries in cases involving child sex abuse and to review the sentences. Is it the sentences and the guidelines or just the sentences?
Oh, it's guidelines for sentencing. Yes.
And the guidelines for child sex abuse cases. All those in favor? Thank you. All those opposed? Motion carries.
It was unanimous.
And I think that concludes the request of the subcommittee, unless Judge D. Leonardo wants to chime in on anything I may have omitted.
No, I don't have anything else to add, but thank you.
Thank you.
Thank you, Judge. Now we will turn to Dr. Souley.
Okay, thank you. So I will be presenting the executive director report today. I have 5 items that I want to review. The first is just to provide an update regarding the November 1st, 2024 sentencing guidelines revisions. The Sentencing Commission issued new versions of the Maryland Sentencing Guidelines Manual and the Guidelines Offense Table, and corresponding updates were adopted in the Code of Maryland Regulations effective November 1. The Guidelines Offense Table was revised to reflect the following. First, classification of new offenses passed during the 2024 legislative session. Second, classification of one previously unclassified offense. That offense was a subsequent violation of Criminal Law Article 5-623C, which includes involving receiving, acquiring, giving, selling, transferring, etc., proceeds, knowing that the proceeds are derived from a CDS offense. The third revision was to revise the seriousness category for 2 offenses. Those 2 offenses included the first violation of the previously mentioned criminal article 5-623 offense, with the seriousness category changing from a 4 to a 5. And then the second revised offense was the misconduct in office offense, which this commission reclassified from a category 5 offense to a category 4 offense. There were other minor edits to the table, none of which I think are substantive enough to discuss right now, but they are all of these updates were highlighted in totality in the guidelines e-news that was distributed on November 1st. Additional update, which I failed to mention at the same time, the sentencing guidelines manual, which there was the new version 16.1, also offered clarifying instructions for sentencing guidelines calculation for criminal events with multiple special applications. Those of you who are with us know we had a lot of discussions about these, but these are things such as the multiple victim stacking rule and the mandatory consecutive sentence rule. And this commission just clarified instructions for the very unique and rare cases where there might be multiple applications of those rules. And so updates were provided that this commission agreed upon. The second item, which I want to discuss, again, and these are all status report items, nothing that requires specific action, but of course we can discuss anything if anyone is interested. Just wanted to provide an update on sentencing guidelines training and feedback meetings. On October 7th, our wonderful training coordinator, Catherine Timebrook, and our newer-ish research assistant, Bella, who joined us in June and was introduced, I think, the July and September meetings, provided an in-person training for parole and probation investigators and supervisors at the Public Safety Training Center in Sykesville, Maryland. Additionally, since the last commission meeting in September, I met with the judges and court staff in 11 jurisdictions. First, I met with the judges in the Second Judicial Circuit, and that includes the judges in Caroline, Cecil, Kent, Queen Anne's, and Talbot County. That was on September 23rd. And then next, I met with the judges in the First Judicial Circuit, which included all the circuit court judges from Dorchester, Somerset, Wacomico, and Worcester County. That was on September 26th. Additionally, I met with the judges in Allegheny County on October 18th. And finally, I met with the judges in St. Mary's County on November 21st. My goal is to meet with the judges in each jurisdiction every 2 years. And these meetings are a great opportunity to share sentencing guidelines, data, to discuss recent updates to the sentencing guidelines, review the work of the commission, and finally to solicit feedback regarding the sentencing guidelines, which has been exhibited already earlier tonight with the feedback that was provided from the judges to the judges in the First Judicial Circuit. The next item I wanted to report on is just to give a review of the protocol for the Sentencing Commission's response to legislative proposals. So I really am doing this because we may have a few new commissioners, and for those who are not new, it's a good reminder. In 2019, this commission specifically adopted a protocol for responding to legislative proposals, and not all legislative proposals, but we were focusing on ones that have an explicit, specific impact on the work of this sentencing commission. So the General Assembly session obviously starts next month. So just wanted to review this. So during recent legislative sessions, there were a few bills, and we're talking about a handful. This doesn't happen very often, that potentially affect the commission beyond our routine operations. And given that this commission does not typically have meetings planned during the legislative session, the commission adopted a policy to guide future responses to legislation that directly affects the sentencing guidelines and or the operations of the Sentencing Commission. So this commission, we assess fiscal and operational impacts of all legislation that impacts criminal sentencing policy. So that's anytime there's new offenses or alters the penalty of existing offenses, which is the most routine bills that we will be analyzing during the session. The staff works on that, and we provide data to Department of Legislative Services and information to them so that they can prepare their fiscal and operational impact statements. But we also just say that these are routine operations. If it's a new offense, if it's an amended offenses, those are routine operations that this commission addresses annually. But it's for the less common, non-routine bills that the commission adopted a specific proposal. So I just wanted to review that now. The proposal goes as the following. First, the staff shall identify legislative proposals that affect the sentencing guidelines or the commission's operations beyond our routine operations. The staff shall then promptly notify the chair of any such proposals and do our best to assess the bill's hearing dates before the relevant legislative committees when known. The commission chair and or staff will then schedule a conference call for the full commission with the purpose of soliciting feedback and to request a vote whether to support, oppose, or take no action on the proposed legislation. Sentencing Commission will provide prompt notice of the scheduled date and time for the call and will offer public access to the teleconference or video conference by publishing a call-in number or a link for the video conference on the Commission's website. The Commission will adopt the majority position of the voting Commission members, provided that a quorum of Commission members participates in the meeting. The chair and the sentencing guidelines subcommittee shall then convene in a timely manner to consider the relevant bills after receiving feedback from the full commission. The chair and the subcommittee will then decide whether it is necessary, and if so, to present the position of the commission to the legislative committees, legislative leadership, and or governor. And then the staff, in conjunction with the chair and sentencing guidelines subcommittee, will prepare formal testimony for relevant Senate and House bill hearings. That's the proposal that we adopted in 2019. And so I just wanted to review that and ask if there are any questions regarding it. So again, last year we didn't have any specific bills like this. We're not, it's more the rare and unusual circumstance. But if one were to come up, that's our strategy that we have to deal with them. Any questions? Okay, seeing none, I will just move on. I have two more updates or two more items that I wanted to discuss. Just to give everyone a heads up about our annual report. The commission has an annual report. It is due on January 31st of 2025. The staff has begun preparations for the annual report. First step in that is data cleaning. It's something we do throughout the year, but we do some final data cleaning before the annual report. Then we'll start working on a draft. Our plan is to have a draft of the report to you all on or about January 17th. And then we will ask for your feedback. If you have any questions or concerns relative to the report, to direct them to me. After we receive your feedback and incorporate changes that are necessary, we will submit the report by the required due date of January 31st. Finally, the last item, I just wanted to give a quick update on the Sentencing Commission's fiscal year 2026 budget. The commission continues to work with the Governor's Office of Financial Administration and Department of Budget Management to complete the commission's fiscal year 2026 budget submission. The Governor's fiscal year 26 budget allowance will be finalized in January. And that concludes my report, and I'm happy to address any questions.
I have one suggestion, if it's not already done. Would you mind sending out the protocol for the legislative proposals to the commissioners, just so that we all have it since that time is coming?
Yeah, so I did include that when I sent out the agenda and materials for this meeting. So everyone should have it at this point.
Thank you.
Sure.
And then just wanted to go over the meeting dates.
Yes, we just want to, yeah, and I guess just officially take a vote to adopt those as the meeting dates for 2025.
Okay. All right. So there are a number 4 proposed meeting dates for 2025. I know that we all get busy.
Yes.
So we would ask that we take a few minutes to review whether or not these meeting dates work with everyone. So first Tuesday, May 6th. When is judicial conference? conference.
One thing I'll note while we're looking at those dates is I think, and anyone can interject, that it's worked out pretty well that where we kind of do a hybrid, where we do 2 meetings in person and 2 meetings virtually. Based on past precedent, I think the best process is to actually have the May meeting in person.
Okay.
July, never want to have in person. That's the hardest one to get. And then the public comments hearing, since that's usually at the December meeting would be the combined public comments and business meeting. I think it
Okay.
makes sense for that to be in person as well. So that's why we proposed that May and December would be in person and July and September virtual meetings. I should have put that in the notes, but.
Okay. Have you all had a chance to look at the meeting dates and your calendars? Even more importantly. Okay. All right, thank you. Is there a second? It's been moved that we accept the 4 meeting dates being May 6th, 2025 in person, July 8th, 2025 virtual, September 9th, 2025 virtual, and December 2nd in person. Moved and properly seconded. Thank you. All those in favor?
Aye.
Okay. Any opposed? Thank you. Motion carries unanimous.
All right.
All right. Is there any old business? Any old business? Any new business? I'm just taking a long time because I know you all want to go home. All right. Thank you. Any announcements? Any announcements? Thank you for the sweet treat. That's my announcement.
Yeah.
All right. Well, thank you all for coming this evening and making your way out. We do hope you all have a restful holiday, if you're able, and we will see you all soon. Thank you. Meeting is
night, all.
adjourned.
Thank you.
Good night.
Thank you.
Thank
Rick, and thank you, Judge
Thank you,
Geniero.
Judge Geniero.
Good night, all.
All right.
Good night.